Hello and welcome to EPR with your favorite environmental enthusiasts, Nick and Laura. On today's episode, Laura and I discuss our illustrious theater careers. We talked to Fred Wagner again. It's great to have him back on the show, and this time we're focusing on waters of the United States, greenhouse gases, and the Supreme Court's role in all of these things. So it's a really, really interesting, as always, a really interesting episode, really, really engaging conversation. Super happy to have him back. And finally, lasers can get trapped in water. This can happen when the light travels through water and gets slowed by the heavier particles in the water, effectively trapping the laser beam in water. So even if you decrease the flow of water, the beam will remain in the jet until it is turned completely off. That seems like mad science, and I don't believe it, but I also read it several different places, so it seems to be true.
But what happens, like the laser continues when it's like freed?
Yeah, it's just like stuck in the water. It's like the light is just there and doesn't go away until you turn off the water.
Okay, well, that one is a mind blower. So
yeah, try it at home, see if it works. Hit that music.
Today's episode is sponsored by Venable LLP. Venable is one of the nation's leading law firms. Venable's management reflects a commitment to diversity and inclusion through a broad category of hiring, training, and educational activities. The firm's environmental practice group works with clients across the country on major infrastructure development, including NEPA compliance and resource agency permitting. Venable encourages volunteer activities in professional environmental associations, as reflected by Fred's membership in the NAP Board of Directors. Don't forget, the NAP conference is coming up May 16th to 19th at the Westin Fort Lauderdale. Women in STEM will be hosting a networking hour Wednesday the 18th from 6 to 7, just after our live EPR session and before Dine Around Town. There will be networking games and mentoring opportunities. This event is for women, and we encourage BIPOC and members of the LGBTQ community and students from local universities to attend as well. Check it out at www.naep.org. Let's get to our segment.
And so have you ever been in a play? By any chance?
Have I been in a play? Don't ask me why I have to think about this, but I guess the answer is no.
It's really like, have I? And I don't mean like...
I'm thinking back to like elementary school. Did I ever like play the flower? No, I didn't.
I mean like, yeah, so like an actual production of a show. That's what I mean. So like,
no, I went straight from never having done anything to trying to be the host of a TV show. I don't.
Yeah, so that's too funny. And so like my high school growing up was it's like one of the things they were known for was drama. Like our claim to fame is Connie Britton went to our high school, and then
who?
She's Friday Night Lights, the wife from Friday Night Lights. She's in a bunch of stuff, American Horror Story, season 1 or whatever. Yeah, and there's this big mural of her in our, mural. It's like a little display case of her accomplishments in our high school. So we had a really robust theater department. We also famously, like my brother was with the blonde woman in Two Broke Girls. That's what I'm doing. Yeah. And it was a terrible TV show, but she was also in my brother's grade. And like neither one of us, well, he remembers her, but like I have no recollection of her at all.
Like Two Broke Girls?
No, no, I did not.
Okay, I've never seen it. So.
Yeah, it was a little too on the nose for me. So they had this theater program, and I just never thought about doing it at all. But senior year, they do this big spectacular where everybody does a play, right? Like they're directing, like some of the students are directing, and so I got to be on one, and it was like the first time I got an entire room full of people to laugh, and it was just awesome. And
is that when a comedian was born?
You would have thought so, but like I genuinely did a thing where I was like, well, I love this. This was super fun. The best I've felt in a long time. So I'm just going to ignore it and go to school and try to be an engineer because that's what people told me that I should do.
Yeah.
And then I was like, oh yeah, no, I don't enjoy math. So, I'll be a psychologist. And then I was like, oh, I need to go get more degrees. So I'll be a biologist. and then I was like, oh yeah, I remember that one play I was in that was super fun. I should do another one. And I did. And it was great. And there you go.
Cool.
Then a comedian was born. So yeah, the path is never straight.
False starts. No, half of my friends were in theater in high school and stuff, but I didn't consider myself a drama person.
Oh yeah.
I don't even like costume parties. I'm not that person who like wants to try to be someone else.
Uh-huh.
or whatever.
That does not surprise me at all.
I know,
by
right?
the way. Oh,
You're so little and boring. Literally boring. Oh my God.
you're just who you are. Yeah. But me, I'm the opposite. I'm like, I wouldn't be everybody but myself. That's what are we doing?
Gotta be me.
Yeah. But I'll throw on an accent. I'll do whatever. Yeah, absolutely.
Well, I am taking this improv class, so I'm excited about doing that.
That's right. Oh man.
If and what it sparks in me at all.
So has it started yet? When does it start?
No, it's starting very soon. So we'll see how it goes.
Oh man, I'm so excited for you to yes and your way through this. I just, I stick with it, by the way. But I think, because they don't get mad that it's boring or lame or something. I don't know. I worry. Like every time somebody says
I mean, the guy, Tanner, who owns a Wonder Bar, queer bar here in Syracuse, he's awesome. He's been teaching improv for 20 years and he's amazing. So I'm pretty sure it's going to be a lot of fun.
Yeah. I mean, as long as you go in with that mindset, you're going to be fine. Yeah. It's going to be great. And there'll be people who are terrible at it. And that's the best part of an improv class. It's just being like,
it'll probably be me, but that's okay.
That's all you got. Huh?
That's why I'm here. I'm here to learn.
Oh, it's too funny. Yeah. I love that though. It's going to be great. I mean, and look, you did like a poetry reading thing or something the other day. Like, so your theater moments are coming. By the way.
That was a storytelling thing. I'm trying to be better for the podcast and trying to also be better for the TV show I'm promoting. So it's all, it's training.
Yeah. And isn't that funny how you do lots of different things to train for lots of different things? Isn't that neat?
It is. But one thing I'm never going to train to be is an attorney. So let's get to Fred's interview because the amount of knowledge that man has is just mind-boggling.
It really is. Yeah. All right. Sounds good. Let's do it. Hello and welcome back to EPR. Today we have our rock star lawyer stopping back by. It's so great to see you again, Fred. How you doing?
It's great to be here. And it's great to be here when it's spring.
Absolutely. We keep joking that nothing is happening in the environmental policy realm because so much of it is, and we're going to dive into as much as we can today. I know we only have a certain amount of time, but we always love starting with some fun because you're such a good storyteller. So I got to know, is there ever a time where you get to use your experience as a lawyer, like outside of your practice?
Yeah, I do. And one most recently was one of the most enjoyable. So my wife is the director of her high school drama club. So they put on a musical in the fall and they put on the drama or comedy in the spring. And this spring, they're putting on a courtroom drama. and it's one of those things where the audience pretends to be the jury, and then they vote on guilty or not guilty, and then the cast has to scurry around and they change the ending of the play depending on how the audience votes. So it's going to be a lot of fun. And so she asked me to come and speak to the cast at the beginning of the production to sort of help them through this whole production and how to think about their roles, their characters, and, really most importantly, to compare to what they see on TV in the movies, and then this dramatization of this, a murder trial on stage. And it was great. The kids asked so many great questions about what if the defense lawyer and the prosecutor, what if they really don't like each other? Stuff like that. Can I show that? Or the judge would say, does the judge ever just get so fed up, with the lawyers that he or she shows their emotion, and they were right on point. It was so great to be able to give my experience in the courtroom, my experience dealing with opposing counsel, whether I like them or don't like them. Ask great questions about coaching witnesses. You know what the witness wants to say? Are you telling them exactly how to say it? Like, cry here. And it was so topical because we pulled up the video. I don't know if you recall in the winter of the Kyle Rittenhouse trial from Wisconsin. And, pretty noteworthy portion of the trial when he broke down in tears. So he couldn't answer questions and they had to stop the proceeding, get his composure and all that. Well, I played that video to the kids. And I said, hey, look, the lawyer just asked a general question about what happened next. And look what happened. What do you think? And every kid, and there's about 30, 40 kids who were watching, said, he's just making that up. Boy, is that an act. I can't believe he's faking it. And I said, well, how do you know that? You're just seeing that. And it was fascinating just to get their reactions to it. And to be able to let them know that, yes, in fact, emotion and real life and come into play in the courtroom. It's not just the facts and it's boring. Sometimes it is. But, especially when things really matter, there's a lot of emotion to it. So I had a great opportunity to be kind of a assistant director to my wife for a day, helping the kids figure out how lawyers really work in the real world, how much is drama, how much is, fake, and whether what they see on TV and the movies is real or not. So that was great fun. And I'm looking forward to seeing the production to see how they do.
That's so cool. I definitely don't need to know the answer to all those questions that they asked, but oh, that's so awesome. I'm glad you got to do that. It's really fun.
It is awesome. But it's a really fun way to do like Parents' Day. So you have kids. Are they high school age? Do they do this drama stuff too?
My daughter followed in our footsteps. So I don't think we talked about this, but I actually met my wife doing theater at college. Yeah. I was directing the show and she was in the show. It was scandalous, I know. And then she ended up directing the shows after I graduated college. And, we continue to do that. Now she's, doing the drama program in high school. So my daughter followed in our footsteps. I mean, almost literally in our footsteps. She went to the same college as my wife and me. She joined the same theater troupe that my wife and I were a part of.
Oh, wow.
Oh, wow.
And she acted in like 4 different musicals while she was there, which is exactly what we did. So that was great fun to go back and see her on stage. And she certainly let all her friends know that her mom and dad met doing the show. So look to your left, look to your right. You don't know what might happen.
Oh, it's fantastic.
Yeah, it's a true story. Great. So yeah, a little bit all in the family. My son did not get into theater, although he has an excellent singing voice. It just wasn't his thing. But yeah, so that's something that's real important to us. And, we're still pretty active.
That's so great. That's a lot of fun. I was trying to throw you a bone there and let your kids still be in high school.
Well, not quite.
Yeah.
Not quite. But
yeah.
That's all right.
All right. Well, that's awesome. I love learning more stuff about you and your family and things. But let's get moving to the stuff people want to hear about. We're going to talk a lot about Supreme Court decisions today. And I have this feeling that people have perceptions about how the Supreme Court works, but may not know exactly how it does. And I may or may not fall into that category. How is it similar and different than a general courtroom? So like you're just talking about telling these kids, maybe they ask you, how's this? Is this Supreme Court or is this county court? Are there any common things or are there myths about either one? And,
well, I mean, certainly the most important thing to know about it is that it really is the top of the pyramid of the legal system. And so things don't get to the Supreme Court very, very often. In fact, you have to petition to get a case before the Supreme Court. You don't automatically get to go to the Supreme Court just because you lose all the way up and you want the Supreme Court to review it. The Supreme Court has discretion on whether it can take those cases. Those are what's called writs of certiorari. The court gets to decide whether the case is worthy. So as a result, in the area of environmental law, for example, when a big case hits the Supreme Court docket, it's extremely noteworthy because it doesn't happen every term. It may not happen, every other term because the court takes so few cases on every subject matter, not just environmental law. So the thing to know about the Supreme Court is that it's a court of its own discretion on the kind of cases it chooses to take. And when it does, it's a red letter day. It's a really big deal. And the thing that's happened in the most recent term of the Supreme Court is, after relative quiet, there's been some cases that have been noteworthy over the last few years, but after just a period of relative quiet, they jumped into the environmental law pool big time and made a huge splash by taking, major cases under both the Clean Water Act and under the Clean Air Act. And they're cases that could potentially have, tremendous impact for years in years to come. And it isn't very often that terms like that, Supreme Court terms like that, come up. And now we've got one, not just one, but two really tremendously important cases at the same time.
Okay. Well, how often do they convene? Are they seeing cases every day or once a month?
Well, I don't know if you know the play. I think there was a play or a movie about First Monday in October. I think that's what it is. That's when that's where in the session. They start their session then. They go through the spring and they rush to get all their opinions out before the end of June, and they take the summer off. So that's a session between October and June. They hear arguments, throughout the session, and they, release their opinions as they happen. But they finish all their opinions for that session by the end of June every year. And so they're scurrying around and burning the midnight oil so that they're all done and they can finish town. They meet once a week to review these petitions for certiorari, like I said, to determine whether they're going to take those cases, vote yes or no. And every Monday afternoon, a long list of cases come out that reveal the disposition of the court. And that's when you learn whether your case has been taken or whether your case has been denied and it's not going to be heard by the Supreme Court. And they do that frequently. And then every time there's arguments, or they meet immediately after the arguments are over, basically just sort of take like a straw vote on kind of where people are, standing on it, just go over any questions they have. And then it's up to the Chief Justice of the Supreme Court, in this case, John Roberts, to, based on how the vote's coming down, to assign who's going to write the opinion, which is the biggest power and authority of the Chief Justice of the Supreme Court, right? Because he or she knows the personalities of the court, can match the case with an individual's leanings and preferences, things that they've written about before, things that they're particularly passionate about before. So when he assigns the majority opinion, that's a tremendous decision and influences how the opinion gets written. Now, other justices can concur. Obviously, there can be dissents and things like that. But if the vote's 6-3, for example, it's the who writes the opinion for the 6 is up to the Chief Justice. He makes that assignment to the others. And sometimes, depending on the case, he may assign himself because it's something that he feels particularly strong about. So, that's how it works. It's they get thousands and thousands and thousands of petitions for cases every year, and they only grant, and it's getting smaller and smaller. The number is getting smaller and smaller. The number of cases they grant certiorari for. 40, 50, 60 at most. So it's an ever narrowing docket before the U.S. Supreme Court.
Okay, awesome. Well, thanks for sharing all that. I have more questions rolling around in my brain, but I know that we need to get to the environmental stuff. So I'll let Nick take over with that.
Yeah, it just means we'll have to have you back and ask more because, I do too. That was really great. But yeah, so you say we have 2 big cases to get to, and I want to start with Waters of the U.S. It's one of the ones that I feel like we've been trying to figure out what on earth Waters of the U.S. even is for the longest time. And it has this really complicated history. So can you kind of tell us a little bit about that history of what is a Waters of the United States, and then walk us through what's going on in the court right now?
Yeah, well, certainly walking through the history is kind of like a 10-part miniseries that's going to appear on Lifetime, streaming right now. The history of WOTUS. But the bottom line is that I graduated law school in 1987, and literally from the moment I graduated to now, the litigation over definitions of organ states is going on. My career has almost been coextensive with WOTUS in some way.
Right.
And the matter's gone up and back to the Supreme Court 4 times. And the agencies, the Army Corps of Engineers, EPA, have been trying unsuccessfully to try to come up with a definition regulations that satisfy everybody. That's impossible. And it keeps on coming back and back and back. The most recent Supreme Court decision on the topic was Rapanos or Rapanos, depending on what Mr. and Mrs. Rapanos say. Their name is how their name is pronounced. But there it was the infamous 4-4-1 ruling. They couldn't find a majority. There was four justices, and another one. In general, it seemed that the opinion written by Justice Anthony Kennedy, who recently retired, carried the day, and that was the substantial nexus test. for wetlands. But there was a competing decision written by Antonin Scalia and the other four saying, this is crazy. The waters of the United States, it's defined as navigable waters. By gum, that's what it should be, navigable waters. And everything else you're trying to do just goes too far and way beyond. Mm-hmm. And so, that was really unhelpful. And I think the one justice, if I recall, Justice Roberts also wrote an opinion there where he basically excoriated the agencies. He said, you got to do your job, agencies. You got to come up with something. And it had been taking so long. And he was extremely frustrated. Well, that's been the ruling and it's been out there, and people have been happy. The Obama administration tried coming back, with a rule. The Trump administration rescinded it, came back with its own rule. The Biden administration rescinded it. And so what happened most recently is that another family, the Sackett's, had been involved in WOTUS litigation for a long time. They wanted to improve their property. The Army Corps said they needed a permit. They disagreed. They went all the way up to the Supreme Court once already. They've been to the Supreme Court on that issue. And the question there wasn't the definition of WOTUS, but the issue there was whether you could challenge the jurisdictional determination. In other words, they got a JD. They said, this is waters, and they went to challenge it. The Army Corps said, no, not final yet. We have to deny your permit before you can go to court.
Right.
And the Sackett's challenged that, went all the way up, and the Supreme Court said, no, you can challenge that. What if they make a jurisdictional determination and then they're going to say no, you have to wait? That's silly. So you could litigate the JD. And so they won. They went to the Supreme Court and they won.
Wow.
So they go back down to the trial court. They litigate that challenge, whether the jurisdictional determination was valid, and they lose.
Wow.
The courts, all the way up to the Ninth Circuit, said, "Hey, no, it is the court did it all right." Well, they weren't happy with that, and so they appealed back to the Supreme Court. Now, remember what I just said, Laura? I'm testing you. What did I say? How often does the court take cases?
Once.
In a blue moon. Right?
In a blue moon, yeah.
Good. You pass. Very, very rarely do they take these cases. And the Sackett's had just been there, remember? Mm-hmm. So nobody thought that the Supreme Court was going to grant cert on this follow-up case from the Sackett's. They just would have said, well, we told you could challenge it. You did. You lost. You got to deal with it. Right. But no, they took the case. And not only did they take the case, but they took the case specifically with the question of what is the waters of the United States?
My goodness.
Basically revisiting the Rapinos decision, the 4-1 decision. But what's different? What's changed since Rapinos to now? I won't quiz you this one, Laura. I'll just tell you. What changed?
I'm going to say a lot.
A lot is also good, but be more specific. Now you have a 6-3 Supreme Court. You have a totally new makeup of the Supreme Court, leaning more conservative. There you go. Ostensibly leaning maybe towards the Antonin Scalia vision of WOTUS, that four, about a very narrow interpretation of WOTUS, dealing just with navigable waters, although it's not clear whether that is true or not. But there's definitely, apparently by the fact that they took the case, an appetite to try to weigh in more clearly, more definitively, because after 30 years, the agencies still haven't come up with something that seems to satisfy enough of the people, including courts. And in the interim, as you know, there have been any number of challenges to the Obama rule, to the Trump rule. There's been injunctions. There have been injunctions that are maybe been nationwide. There have been injunctions that have just been in certain parts of the country. There have been stays. There have been challenges to the injunctions. It's just a mess. So on the plus side, this is an opportunity to perhaps clear some of this stuff up. What's weird, of course, is that the Biden administration is still in the process of writing a rule.
Yeah.
So what's going to come first? The briefs for this case are due in April, May. Okay. There will be arguments in the fall. And the decision likely will be in the winter, early spring. But it could be one of the last decisions. Remember, end of June.
Right.
It could be all the way to the June of 2023. We don't know. So many Republicans in Congress have said to the Army Corps and EPA, stop writing a rule. Don't be silly. We're going to hear from the Supreme Court. You're going to have to redo it anyhow. There's not been, we haven't heard from the agencies whether they're going to agree to that or not. But we know there are these parallel tracks, the Supreme Court and the agencies trying to move along. But my sense is that the only reason the Supreme Court took the case was because they felt they needed to offer some clarity. Mm-hmm. And, whether folks will be pleased or displeased with that clarity, remains to be seen. But there's a strong supposition amongst the people who litigated these issues before, whether it's in a trial court or whether it's on appeal, that they're going to come out with a more definitive ruling, and it will likely be leaning more towards the Scalia test, the more narrow interpretation of waters in the United States, than the broader substantial nexus test.
Interesting, man. So
would not be shocking.
Yeah, no, it would not. But it does spark a question for me. So I think one of the hardest things for people, because what is a waters of the United States seems like it should be pretty easy, right? Like if you say it's navigable waters and that's it, but then you think about, well, everything that comes into a navigable waterway and who's responsible for putting what into the river. And that's where it starts getting gray and complicated and crazy. So if that is the decision, say there is a decision that they make and they're like, it's only navigable waterways, is that a final decision, or is there a time that we're going to get to, maybe not now or even in the next decade or so, where they can revisit something they've already answered and they say, no, we already told you what this is? Do they ever take those back up and say, you know what, maybe we didn't do it right?
Well, I'm not getting political here, but the answer clearly is yes. Look what they're doing in the abortion cases.
Yeah.
Everyone thought that was done and decided, and now there's a feeling that for whatever reason, whether it's pure politics or whether there's some basis for saying there's been new information or changed circumstances, the court's revisiting its prior ruling. So yeah, they could do that. I mean, the more likely scenario, let's say, is that they come up with something that's very restrictive and very narrow. And the feeling is that I'm just making this up. I don't think this will happen, but it restricts regulation of all wetlands.
Mm-hmm.
Because if you can't take a boat on it, it's not regulated, let's say. Again, I don't think it's going to be that extreme, but if they go that extreme, well then, guess what? The ball's directly in Congress's court again. If there, becomes a majority and a president that will sign a bill, they can go back and say, maybe we messed up. Maybe we originally, when we wrote this, we didn't provide the clarity that was necessary. We went up to the court several times. The court in 2023 issued this ruling that said this, but you know what? We feel bad about that. So now we're going to legislate in a certain way to answer some of those questions. I mean, that in theory could happen. And once the court rules, it's rare that the Supreme Court would revisit that, in a year or two or five. It tends to have to marinate there for quite a while. I mean, obviously Roe, you're talking about, 50 years now. But even there's a strong debate whether, the court's adherence to stare decisis, it's called, its own precedent, is, whether they're really sort of punting on that principle.
Yeah.
By just changing it because, as I said, not making a political commentary, but just because of political reasons and their own personal views, they want to reverse it. They didn't agree with Roe, and now they're 6 instead of 4, and they can't. And so they're gonna. How often does that happen? Thankfully, not very often, because the principle of precedent and stare decisis is crucial to the viability of the Supreme Court. So if they narrow it, that'll be it, Nick. Unless and until Congress says, oops, that was their interpretation, but we didn't mean that. We need more protection, so we're going to do this now instead. So in 2024, Congress passes the Wetlands Protection Act of 2024, right?
Right.
That could happen. But if the court issues a ruling, that's going to be its ruling for quite a while now.
Wow.
Thank you for that explanation. If I didn't have questions before, well, I have questions now. But speaking of flip-flopping, so the Biden administration has also reinstated the social cost of carbon to Obama-era levels, and then that was immediately met with injunction and then a stay and then removal of that stay. So this kind of like flip-flopping and back and forth, like, is this common or is this getting more proliferant? Oh my God, this is why I'm not an attorney.
Prevalent.
Prevalent, thank you.
Yeah, we'll edit that one right now. Prevalent, absolutely prevalent. Yeah, no, it's unfortunately becoming more normal than not. That's the bottom line. And even as a practicing lawyer who sort of get the buzz out of, important environmental cases like the case we just discussed in front of the Supreme Court, and we'll talk about the greenhouse gas case in a moment. But what's happening more and more, unfortunately, is that something is decided by an agency or some policy, some guidance, and it is immediately challenged. And not just challenged by a stakeholder, somebody who's like subject to a permit requirement, right?
Yeah.
Or an association that has comments on a rule or something like that. But like the opposing political party governors get together and they challenge it because guess what? They disagree with it and they want to put a stop to action in a particular area. That's what happened with the social cost of carbon. It wasn't even a rule. It wasn't even guidance. It was just like some hint for the agencies to say, here's a way you can try to deal with this, when we're trying to grapple with greenhouse gas emissions and what does this mean for federal policy. Groups of Republican governors sued in one court and lost. Another group or subset of the same group sued in another court, and they got a judge in Louisiana to agree with them and put this injunction in place. And literally just 2 days ago, the Fifth Circuit overruled that injunction and lifted this stay on the application of social cost carbon. So there was this 2-month period of complete total chaos about what they could do and not do. And if they're not applying the social cost of carbon, but they're still doing some greenhouse gas analysis in general, is that the same thing? And should they be stopped from doing that? I mean, it was a mess. And the sad reality is that's happening more and more. It's hardly a day goes by where, an agency can feel like it's doing something. It's making a decision or provide some guidance, then it doesn't go down the route of litigation, from members of Congress, from governors, and so forth. And it creates this constant stream of decisions and potential injunctions and back and forth and uncertainty. It's kind of like WOTUS has now infected itself across the entire spectrum of environmental law. And that ain't good.
Right. Yeah.
And the old saying, when you deal with clients is a client can take bad news in terms of, how regulation works, as long as they know what the news is. They can deal with something if they have some certainty. You are going to have to, modify your factory to deal with this pollution issue. It's like, okay, at least we know about it. We can plan our investments. We can plan the modifications to our factory. We can do it because at least we know. What they hate is, well, you might have to, or you might not have to, because this is the rule now, but it's being challenged tomorrow, and there's an injunction on Thursday, but it's lifted on Monday, and don't put that order in for that equipment now because you may take it back, and of course the equipment is millions of dollars. They hate that.
Yeah.
And what we're seeing, sadly, is this happening more and more and more, and anything that's remotely controversial, whether it's greenhouse gas, whether it's waters in the United States, whether it's the regulation of PFAS, you name it, anything that's hot and creates an issue ends up in this cycle. And as a lawyer, counseling clients, it's extremely difficult. And for our environmental professional friends listening, it's equally difficult because, you're responsible for figuring out how to fill in the blank. Write the permit application, do the audit of the facility, write the analysis of impacts, doing a jurisdictional determination, knowing if the habitat of the sage grouse is protected or not protected. And unless you look into the court digest and understand what the opinions are, you don't know how to do your job.
Right.
And so there was always an element of that, of course, because, the case books are, replete with environmental cases, obviously, for forever. But not like this. Not like this, a decision in one circuit, but not in the other circuit, and governors going here, but not there, and splits of authority. It's not like how I remember it growing up in the law.
Right.
Just not at all.
Well, and then for people working on the permitting side, they have to deal with people seeking permits and customers who think they know better or think they can wait and change the rule or think you don't know what you're doing because you're in the middle of, I don't know what the rules are doing at the moment. And then I've seen them pull their weight around and try to, get their way just by saying, well, it's going to change or you don't know what you're doing. And that is an additional frustration. So appreciate you here, Fred, sharing this info.
Well, and what it means to me, I think, for both the legal perspective, working with folks in the environmental sphere, as well as the technical folks, working with clients, the common theme in light of all this is how do we assess risk? how do we assess risk for our clients? If you do it this way, we think that's protective and will be defensible. Client comes back and says, yeah, but if we do it this way, it's going to be so much more expensive. It's going to be very inconvenient for us, right? So we'd rather do it that way. Your response is, that's fine. I'm not saying you can't do it that way because, again, as you pointed out, it's either debatable or we're not quite sure how the courts are going to come out. But then we're all in the position, lawyers and technical professionals alike, to help our clients assess the risk. Will this pass muster? Will we get approval from the agency? If we get approval from the agency, would it survive, a court challenge, and so on and so forth? And in that way, I think that's kind of a common bond that this latest trends that I just described, that's the common bond that I have with you guys. Besides the fact that we love our jobs, it's all that, but that's the common bond. We just don't do our jobs in our own disciplines. Yep. We are now professional risk assessors to help our clients know what to do. Absolutely.
So you mentioned cost of carbon in there a few minutes ago. What is that? Why does it matter? Where do you see that going?
Well, the important thing for the social cost of carbon is the measurement and assessment of greenhouse gas effects generally. So when I think about it, there's the more narrow factors like emissions themselves. If you do this, can you calculate the emissions? Mm-hmm. And there's any number of tools to help you do that, and that's fine. What social cost of carbon gets to, which is a little bit more than that, which is, okay, in light of those, how do we calculate the impacts of that, short term, longer term? How do we deal with the cost, both in terms of the global environments, but also, the thing that we're doing? So, for example, resilience, how are we working in resilience to the infrastructure that we're building, so forth. So, to me, measuring emissions is one thing, but social cost of carbon goes to how do we try to quantify, even if it's quantitatively or even qualitatively, what does that mean if we have X amount of emissions over Y period of time? What does that mean in terms of the overall impact on the environment? And that is anything but simple. Mm-hmm. It's certainly in many ways subjective, depending on who's doing the analysis. But what the government is struggling with in any number of contexts, NEPA being one of them, if we're trying to describe what this is it truly helpful to say that we expect X number of tons of carbon from such and such a project? Or is it more helpful to say, if we are to see X number of tons of carbon from this project, what does that mean to us?
Right.
And that's really what it gets to. And one way or the other, the federal government's going to have to grapple with it, whether they apply the social cost of carbon metric or whether they apply some other kind of metric to describe what that really means. That's what we're seeing. And, court after court is coming down with rulings that say, no, greenhouse gas is an impact just like any other impact. Mm-hmm. And you have to figure a way how to assess it. And I think the CEQ guidance that we're expecting on how to incorporate GHG analysis into NEPA documents will be crucial. How the government now, since the injunction is lifted, they can, again, give guidance on applying the social cost of carbon. All this will contribute to that analysis, how different agencies build in the assessment of those impacts to their actions. And that's what it's all about.
Okay, so is this coming up to the Supreme Court level, or they're venturing into greenhouse gas?
The social cost of carbon probably won't, because I think the ruling that was just reversed, it was so off the wall. I mean, many, many people felt that it was susceptible to being reversed, even in the Fifth Circuit, which is one of the more conservative circuits in the country, that it's unlikely the Supreme Court would venture into that because, again, if the Fifth Circuit is disposed of it, it's probably not going to get to the Supreme Court. What is at the Supreme Court is the EPA's and the government's ability to regulate greenhouse gases generally. And that's in the case, the challenge to the Clean Power Plan that was just heard, and it was argued at the end of February. And a ruling may come out, relatively soon, maybe by the spring on that topic. And there, the whole question is whether, EPA or any other agency for that matter, has the authority under the Clean Air Act to regulate greenhouse gases under what's called the Major Questions Doctrine. Okay, the Major Questions Doctrine. Now you may say, "Hey, wait a minute! I thought the Supreme Court dealt with this in Massachusetts, Massachusetts v. Browner, and said that greenhouse gases, the determination that greenhouse gases were a pollutant was fine." Mm-hmm. And you would be right, but again,
that's exactly what I was thinking. I don't know.
But then again, we have a 6-3 court, and part of the 6 majority are conservative justices who have been itching to find a way to rein in the discretion and authority, not just of EPA, but of all federal agencies under what's called the Chevron doctrine. For years and years, it's the name of the case. The Chevron doctrine is one that governs how a court reviews regulatory actions by an agency. And in general, there's broad discretion, and the agencies should be upheld unless they abuse that discretion, something bad. That's called the Chevron doctrine. And a lot of these conservative judges and around the country, not just on the Supreme Court, are taking issue with that. It was almost like there was so few instances, they argued, where an agency went beyond its discretion that the doctrine was swallowing the whole. There was never a case where they abused their discretion. And so, this question of the major questions doctrine sort of came about as a more conservative jurisprudence principle to say, hey, look, is there something that's so fundamental, so huge in terms of its economic impact and regulatory impact, that unless Congress was bloody clear, we cannot assume that an agency has the authority to take action. That's what the major questions doctrine is all about. A lot of people are critical of it, for a lot of reasons. But that was, in essence, the bottom line for this challenge. And it didn't go to whether a greenhouse gas was a pollutant. It went to the basic question. The Clean Air Act didn't mention this thing called greenhouse gases. It did not. And to the extent the agency wants to regulate them, in this case, in the context of power plants, unless there's something said, we may agree or we may disagree that this is something the EPA, should regulate as a matter of public health and safety. But it's irrelevant because Congress didn't say so expressly, and we cannot presume the agency has this authority unless Congress acts. That's what this court may be dealing with. And that's why many people in the environmental community are petrified about what a negative ruling could mean. Because if they come out and say, no, Congress has to act, and you can't take steps to control or regulate greenhouse gases, as we talked about at the beginning of the podcast, what are the odds of Congress acting these days? Very, very small. And so the worst case outcome from the environmentalist perspective has been, sorry, we may think that greenhouse gases and climate change is an existential threat, but you know what, agency, without that express written authority from Congress, you really can't do anything. So Congress, do your job. And people are really worried about that. Not just for greenhouse gas, but you can think about any number of other scenarios where the EPA is addressing PFAS as another example. Mm-hmm. What about that? We've known about them for a while, but can we regulate them differently under the hazardous waste laws and so forth? And you could just imagine a decision that says that Congress has to be, more express in its direction to the agencies, triggering a whole bunch of litigation from opponents of environmental regulation to say, hey, look, I don't read this in the statute. I don't see Congress saying this. So EPA or Interior or whomever who's doing environmental or natural resources regulation, sorry, you can't do it unless and until Congress says so. So there's a whole bunch of people really on edge, depending on what's going to come out of this Clean Air Act case. And the oral arguments were pretty muddled. I mean, there was not a clear sense that there were 5 justices ready to jump to the extreme, but nor was it clear that there were 5 justices ready to say anything, really, that was going to be useful here. So it's one of these cases where until we see the opinion, it's very hard to predict, how this is going to come out. And then once it does, the potential is for an earthquake in the field of environmental law, or maybe just a small tremor, depending on how the justices end up writing their ruling. So it's one of these huge wait and see moments. I mean, literally a cliffhanger. To go back to my theater analogy, this is this is a cliffhanger that I don't think many people can predict exactly how it's going to turn out.
I mean, my gosh, and I know maybe I shouldn't ask this question, but I can't help myself here. So if the Supreme Court is taking on cases that they've already reviewed, and they keep doing this in a way because they have a new court, and if they keep passing things that overturn what a previous court has said, does that do anything? 'Cause in my mind, that immediately tells me that that's a political thing that they're doing. The court's supposed to be apolitical, but these are concrete examples of them genuinely being political, whether they want to admit it or not.
Yeah.
And do they weigh that in when they're having these conversations? Is that something they think about?
They do. And if you read some of the dissenting rulings from the vaccine case that I talked about earlier, I think Justice Kagan raised this. I think Justice Sotomayor raised this. They said straight out, Nick, that we fear for the future of the court.
Yeah.
Because it's going to give the impression exactly as you portrayed it, that we are no different than the candidates running for office.
Right.
We take a political position depending on our personal views or the views of the people that appointed us. And you know what? That is not what the Supreme Court is all about. It's just not. And I have to tell you the story. And again, it's not a political statement, but my wife and I had the pleasure of meeting Merrick Garland in the middle of the time when his nomination is being held in limbo to the Supreme Court. And my wife, being the government teacher, asked the judge, said, my kids always ask us, you just got appointed to the court by Barack Obama. A case comes before you that's clearly really important to President Obama on whatever subject matter.
Yeah.
And now you have to rule on it. Do you really truly rule in a way that doesn't take into account that you got your job because of this guy?
Yeah.
And he smiled, and he's a very gentle man, very gentle soul. And he said, Mrs. Wagner, you can tell your kids that it's absolutely true. We do not take into account who appointed us or what it is. We look at every case on its facts and make the best decision under the law. And you could tell through the passion in his voice how strongly he believed in that. And my fear is that these reversals, without strong justification in law as to why the court would do so, chips away at that bedrock principle. And
right.
It's this kind of sad commentary on where we are, that folks may not have the same kind of faith that they should have in an institution like the Supreme Court of the United States.
I know. I know. And it's frustrating. Like you say, a little scary. And we've got cliffhangers everywhere. And I would love to say we're going to segue into something less dramatic, but this is a show we have. So I don't know. One of the things we've been talking to you about since we started was the Environmental Justice Initiative for the new administration. And, there's a Environmental Justice for All Act, which would open legal avenues to communities to sue over environmental discrimination and add programs and regulations to ensure marginalized communities don't suffer from disproportionate environmental harm. But that saw heated arguments in the House and is something that I don't know if it's possible to get through. But we know EJ and equity enforcement are coming out from different agencies like EPA and Department of Justice and others. So what can we kind of expect to come through on the environmental justice front?
Yeah, don't expect legislation, first of all. I just don't see that getting enough traction. Certainly, if one or both of the houses flip, after November, that's absolutely not.
Oh, yeah.
But you are going to see, literally, I would say dozens of individual actions from agencies around the federal government dealing with equity issues in any number of different ways. There are going to be rulings on Title VI petitions, in front of EPA, in front of HUD, in front of DOT, where the agencies are going to say yay or nay that there were, violations of Title VI and the agencies did not properly take into account effects to disadvantage of minority communities under the act. You're going to see that. You're going to see enforcement actions by EPA where the potential violations are particularly harmful to marginalized communities. There's an absolute emphasis. If you have a choice between 5 different enforcement actions, you're going to pick the one at EPA that is adjacent to or nearby a minority community. There's just no doubt. And there's going to be a lot of those. You're going to see permit reviews, where, local communities challenge permit reviews because they claim that the state permitting authorities haven't adequately taken into account the cumulative effects of other permitting decisions in and around the communities over a period of time. And EPA is going to be coming out soon, Nick, with cumulative effects guidance, specifically designed to help agencies figure out how do you take that all into account. Not NEPA cumulative effects, which is sort of like environmental general cumulative effects. Now, P.S., I do think that'll have a carryover effect for NEPA, but that's a discussion for another day. So you're going to see that. You're going to see guidance coming out of the CEQ on the Justice 40 initiative on how agencies should be calculating the relative benefits of their actions for minority communities. Again, thinking that with the goal of 40% of all expenditures having those effects to help those communities. And that guidance is coming out soon. You're going to see between now and I would predict the end of the year an inordinate amount of individual actions or guidance or directions to agencies on how to deal with all these issues. And then circling back to our whole discussion today, guess what happens next?
It gets litigation. Yeah.
It gets litigation.
Yeah.
And then you're going to see litigation from the courts discussing the scope of authority under Title VI, scope of authority under the Civil Rights Act, how much environmental justice can or should be used in the consideration of these decisions. And, we'll be having this discussion a year or more from now about some of those rulings and whether the discretion of the agencies was upheld or not based on a whole variety of actions. So don't hold your breath for congressional action.
Right.
Do hold your breath because you can see an abundance of agency action. And then it's just a matter of then waiting for the other shoe to drop on whether those decisions, those regulatory guidance documents are upheld or not.
Yeah. Like I say, it's a wild, wild time. It just really is. And so... Yeah,
my head is spinning. I don't know if you do this every day, Fred, and not just like go bonkers. Must have ways to disconnect, and maybe we can talk about that next time too.
And who's to say that I have not gone bonkers? that is for you and the audience to decide.
Well, as we continue to have these conversations with you, we will keep an eye out for signs. But we are pretty much out of time. Is there anything else we missed that we should quickly mention before we leave today?
I think, I don't think we covered it all, but we certainly covered the highlights and the things that folks, I think, will be reading about most in the newspaper. Put it that way.
There we go.
The things that'll make the headlines, I think we definitely covered.
Perfect.
Awesome. Thanks so much.
Yeah. And thank you as always for your time, Fred. It's so great to catch up with you. Hopefully we'll have better news next time, but it's still really great to hear what's going on. And I genuinely appreciate your thoughts and opinions here. So before you leave, tell the people where they can reach out to you.
Definitely. At any time people want to chat about these or other topics, reach out to me at frwagner@venable.com. Venable is a proud sponsor of the podcast. We were so happy to be doing that again this year for you all. And you can do that looking at the Venable website and tag me and email me. Love to hear from people.
Awesome. Thank you, Fred. Really appreciate it.
All right.
That's our show. Thank you, Fred, so much for joining us again today. Please be sure to check us out each and every Friday. Don't forget to subscribe, rate, and review.
Thanks, everyone.
See ya.